Hi, I'm Aslam and I am a registered attorney, and in today's video we're going to be covering what is the difference between poor work performance and misconduct. This is part of our video series on poor work performance, and it's to further explain that difference because it is a critical difference. Both misconduct and poor work performance can lead to your dismissal. In other words, you can be fired either for misconduct or poor work performance. There's no escaping it. But the way that it's handled is very different. So let's start off with misconduct. A misconduct is something that you do wrong at the company, or rather, something that you are accused of doing wrong at the company. The company must have proof of the wrongdoing, it must need witnesses, it must have evidence, and then there must be a disciplinary hearing together with an outcome. You can then take an unfair dismissal to the CCMA. That is for a misconduct. On the other hand, you have a poor work performance. Poor work performance, as the name implies, is that you allegedly are not meeting the expected standards that are imposed on you. These standards could either be in your employment contract, in your performance evaluations, in your KPIs, etc., etc. The poor work performance is very different to the misconduct. Under poor work performance, the company must first have counseling sessions with you. In other words, they must first notify you in terms of what the expected standard is, offer you training and support, give you a time to improve your performance, etc., etc. More on this is covered in our other two videos. In my view, as a labor lawyer, I believe that the poor work performance is much more onerous way of getting somebody dismissed than a disciplinary inquiry. Because for misconduct, all you need is evidence of the misconduct. Yes, the company needs to prove it, and then you have a dismissal. Under poor work performance, the company must first counsel you, must then offer training and support, must investigate the reasons why you are not performing to the expected standard, must give you reasonable time to improve, must do anything reasonably possible to get you up to the required standard. And only when you can't get there, then the company must have a poor work performance inquiry. We've done a whole video on how to prepare for the poor work performance inquiry, and a link to that is now shown on the screen. However, the poor work performance inquiry is similar to the disciplinary hearing in that you must still prepare, the company will need evidence, you must counter the evidence, there's still opening statements, there's still closing statements, etc., etc. And you can also challenge that at the CCMA for an unfair dismissal. The two broad areas are misconduct, disciplinary hearing, that's the one area. The second is poor work performance, and then a poor work performance inquiry. Both are very different and they both have different requirements. If you need help in your situation, you're more than welcome to click the link below and book an appointment with our office. I wish you all the best, and I'll speak to you soon.